Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, listen, we get that we cover a lot of topics around here that can be rather infuriating. And trust me, I'm the one that has to go through these briefs and read them. And yeah, they can make your blood boil sometimes. Along every now and then comes a brief where you're just like, wow, I can't believe they're actually saying the things they're saying and the tone that they're taking. And maybe this is indicative of what's happening with the progressive movement on a nationwide level. They've run out of talking points, they're detached from reality, and all they got left is nastiness and violence. This brief doesn't necessarily advocate for violence, but it does set a pretty terrible tone. So today, let's spend a few minutes and let's talk about the nastiest gun control brief you'll ever read. Okay, America, and in particular out to all my friends out there in Illinois, the case we're talking about today is one of the several challenges to one of your several assault weapon bans. This one is the matter of Viramontes v. Cook County. For those of you who don't live in Illinois, one, congratulations. Number two, understand that they don't have a state preemption law. So you got cities like Naperville and you got counties like Cook County that can also pass gun control or civilian disarmament legislation, such as the case is what happened in Cook County with their own independent assault weapon ban. This case was appealed to the 7th Circuit. It was obviously an unsuccessful appeal. It now goes to the United States Supreme Court by petition of Viramontes, and what we have here is the Cook County response brief to that petition. Basically, Cook County saying, hey, there's no reason for the United States Supreme Court to take this case. Now, normally we don't talk about the signatories, those who signed the brief, but here's who they are. Because I got to tell you something, whenever they woke up that morning to write this brief, someone must have peed in their Cheerios. Because this is absolutely one of the most nastiest, most distorted briefs you will ever read. I will give you only some examples. We'll link it all up down below so that you don't have to take our word for it. Now listen, just like with a court opinion, anytime a memorandum starts with just a whole bunch of horror stories, you know where this is going. And that is exactly what the attorneys for Cook County have decided to do here. As a matter of fact, they start with the Uvalde shooting before even moving into something closer to home. They then spend, as you can see here, pages 1 through 4 describing every type of horrific, violent act that was allegedly committed with a semi-automatic rifle. Now, I said that in many ways, this memorandum here kind of mirrors what's going on with the modern progressive movement in general, which is now that they've lost all of the talking points, about all they can attempt to do is equate anything of a conservative or traditional American value as being Nazi-like. Don't believe me? This is where they start in their historical description of the semi-automatic rifle, or in this case, the AR-15. To understand how a single weapon could be utilized to such devastating effect in the Uvalde massacre, those which preceded it and all those that continue to follow it, one must understand that the assault rifle's origins as a weapon of war. In 1944, Germany's government began arming its troops with the Sturmgewehr. And there you have it, the modern sporting rifle, the modern semi-automatic rifle, the AR-15 was born, that's right, from Nazi innovation, according to Cook County, Illinois. And a consistent theme that is weaved throughout this entire memorandum is hey, listen, the AR-15 and the M16 are essentially the exact same firearm. And I want you to understand, America, this is a very dangerous argument, because when you take a look at some of the other definitions, not only on a state level, but on a federal level, of that which is readily convertible, this is an incredibly dangerous argument to take machine gun bans and have it spill into all other platforms. Cook County sees it this way. The AR-15 has the same performance characteristics in terms of muzzle velocity, range, and ammunition as the M16. And of course, all of that is based on ballistics, which has absolutely nothing to do with rate of fire, but more muzzle velocity, the type of ammunition, barrel length, and all of that stuff. But hey, don't let the facts get in the way of a good argument. Now, as if the horror stories that Cook County shared in pages 1 through 4 were not enough, they then waste pages 8 through 9 coming up with some of the most crazy stories about what can be done with an AR-15. And when I say crazy, I'm talking about things such as where an AR-15 left a back wound that caused the thoracic cavity to explode. A heel wound where the projectile entered the bottom of the right foot, causing the leg to split from the foot to the hip. 3 shots fired from an AR-15 decapitated the enemy combat and severed his right arm. And of course, they don't cite any authority to any of these horror stories, but hey, once again, why let the facts get in the way of a good argument? But it would seem that if this firearm was so lethal, it would be incredibly effective for self-defense, right? Wrong. Not according to Cook County, because the firearm experts there at the Cook County Attorney's Office believe the following. While these characteristics make assault weapons more lethal, they also make them less useful for ordinary self-defense. But now in what is perhaps the most outrageous claim in a very outrageous brief, the most infuriating of claims in a rather infuriating brief, Cook County, Illinois, actually argues with a straight face that merely possessing a semi-automatic rifle, possessing an AR-15, will motivate an individual. The possession of an inanimate object will motivate an individual to go out and commit violent crime. Not making it up. This is the exact quote from their memorandum. More troubling, the mere presence of a firearm tends to encourage violence. The use of assault weapons in previous massacres increases the likelihood that aspiring mass shooters will use them as a form of mimicry. This natural physiological effect is only compounded by the fact that assault weapon manufacturers market them as cool and intimidating military weapons. Did you see that? That's literally the argument they're making, is that the possession of this firearm will in fact motivate people to criminal activity. And this is the problem with the civilian disarmament movement altogether, is that, you see, liberals don't want to trust you with guns because they don't trust themselves with guns. That's the problem. They're projecting their insecurities and their emotional deregulation onto you. More troubling than that, though, Cook County, Illinois actually believes that the possession of a semi-automatic rifle will encourage mass shootings and discourage law enforcement from trying to do anything about it. This is their exact quote from their memorandum. Assault weapons also encourage mass shootings by deterring effective, prompt law enforcement intervention. Effective responses to assault weapon shootings require specialized protective equipment. Now, ultimately, they do get to some semblance of legal arguments. And of course, it's the usual suspects. But the first one is one that we have talked about, especially as we've talked about the cooperation that we've received from Magpul and from Palmetto State Armory and from Duramag about this ability or need to make a record at the lower court levels that these firearms are actually in common use for lawful purposes. Viramontes cut some corners here, and I get it. It's an exercise in futility. I get what plaintiff's counsel was doing there. But now it comes back, and it's used against them in the following fashion. As a result, while the county diligently endeavored to compile a record to defend its ordinance from his constitutional challenge, Viramontes neglected to even participate in discovery. It thus came as no surprise that the district court summarily rejected Viramontes' challenge to the ordinance for simple want of supporting evidence. And of course, they also say, well, and that for that reason, the Seventh Circuit was justified in upholding that ruling. Now, one of the other things that they like to point out, and again, this is a product of what we like to call around here jurisdictional bubbles, is the fact that at the current time, there appears to be no circuit split on this issue. And so Cook County argues, Viramontes' petition stumbles immediately out of the gate over the fact there is no conflict amongst circuits regarding the constitutionality of assault weapon bans. And then again, with the inclusion of all of this nasty and unnecessary language, but this is the way Cook County wants to handle it here, they point out that, well, the circuit split that Viramontes is talking about, where does common use come in, where does the text, where does the history, where does it all apply to this equation, that doesn't really constitute a circuit split. They, however, put it this way. That leaves only Viramontes' last gasp attempt to sow the specter of uncertainty regarding the meaning of common use. Okay, America, the case, once again, is Viramontes v. Cook County. Now, the respondent's brief was just filed on October 29th, and the case is not yet scheduled for a conference. We will keep our eyes on it. We're going to link up the brief down below. Listen, it's an infuriating one, so you know the drill around here, okay? 3 fingers of bourbon, breathing exercises, or a barf bag. You're going to need one of the 3 before you do this. Okay, now listen, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, that link is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.